to start the hearing. Could I ask the subcommittee members to come on screen, please? Thank you very much, members. Councillor Hodges will be joining us shortly. Councillor Bruce, just to let you know that your camera is not on at the moment.
I can see her.
I can see her as well. Yeah, it is on.
Okay, but no worries. We'll get started and then we'll
switch off
check
and
everything.
switch on and see if that
Okay,
helps.
thank you very much.
Any better?
Yes, I can see you now. That's lovely. Thank you. So, good morning all. Thank you very much for joining us for the Planning Subcommittee Public Rights of Way meeting on Wednesday, the 6th of September 2023. My name is Amy Rudman. I'm the Democratic Services Officer supporting the meeting today. May I remind everyone present that the meeting is being live streamed as well as recorded via the internet, and this recording archived for future viewing. Could all participants please mute themselves when not speaking in order to avoid any background noise or feedback when other participants are speaking? If a participant wishes to speak, can they please put their hand up using the raise hand function in Microsoft Teams? If a participant raises their hand via the function and is not subsequently invited to speak by the chair, please could they turn their camera on to indicate or place a message in the chat function. When invited to address by the chair, please could all participants ensure that their microphone and camera is on to ensure that they can be seen and heard when actively participating. If this is not possible for any reason, please bring this to the attention of the chair or myself as soon as possible. Please ensure that all debate is raised verbally and not via the chat function for the sake of the recording today. The chat function may be used to highlight any technical issues and/or to grab the attention of the chair or myself. If any participant has difficulty hearing or being heard when they're addressing the committee, then please let myself or the chair know. That concludes the housekeeping for this morning. You will see from your agenda papers this morning that our first point of action is to appoint a chair and vice chair. So could I please begin by asking for nominations for chair this morning, please? Councillor Drake?
I'll nominate Councillor Neil Thomas.
Thank you. And Councillor Williams, are you seconding by your indication? Thank you. Are there any other nominations from the committee this morning? Okay, as that is uncontested, I duly elect Councillor Thomas as the chair for the meeting, and for the remainder of the municipal year for the subcommittee. Councillor Thomas, would you like to take us through nominations, please, for vice chair?
Yeah, thank you, Amy. Thank you all. A nominations for vice chair, please. I'll nominate Councillor Drake in the absence of anyone else. Is Eddie, was that a second? Thank you very much. Any other nomination? No. There you go, Pam. Thank you.
Thank you,
Well
Chair.
done.
If I may, Chair, at this point, if you don't mind, just to make some formal introductions for your benefit, you do have 3 public speakers for the hearing today, all of whom are connected. Mr. Ali, Mrs. Medhurst and Ms. Cox. They have tested their technical capabilities this morning with myself, and all seem to be fine. Councillor Hodges will be joining us shortly. You also have Mrs. Thornton, who is the legal representative from the Vale of Glamorgan Council, with us this morning, as well as Mr. Hunt from the Public Rights of Way team from the Vale of Glamorgan. You also have 2 guest consultants who are also connected and have tested their technical capabilities. That's Ms. Goodman-Jones, who is here for agenda item 6 this morning, and Ms. Sharples, who's here for agenda item 7. You also have Councillor Charles who is observing the hearing as an elected member of the Vale of Glamorgan Council. She is entitled to do so. Thank you, Chair.
Thank you, Amy. Next item on the agenda then is the apologies for absence. I take it there are none except for Councillor Hodges, who you already said is going to be late.
That's correct, Chair. I have spoken to him just before the hearing started. He's just having a couple of technical difficulties, but will be with us shortly.
Thank you very much. The next item then is the minutes of the meeting held on the 13th of January 2022. I was not at that meeting, but I think, Pam, you're the only one who is now present, who was present.
Yeah, I think I was as well, Chair. Am I right in thinking that?
Yes, you were present as an observer.
So, I'm happy to move the minutes.
Thank you very much, Eddie.
I'll second those.
Thank you, Pam. I take it there are no matters arising from that either. Right, we come on to item 5, which is declarations of interest. Do we have any? No, thank you. In that case, we move on rapidly to item 6. And
you have Mr. Hunt on the line for you, Chair. He will introduce, and then he will bring in the guest consultant.
Yeah, and I believe that we have a speaker on this, but he's speaking for, which means that he comes after the presentation, right?
It's Mr. Ali. Is your public speaker. He's actually speaking against. He has confirmed that with myself. So obviously we would go through the introduction from Mr. Hunt first, then the presentation of the investigation report from Ms. Goodman-Jones. Then we'll bring in Mr. Ali as a speaker.
Okey-doke, thank you very much for that. In that case, Mr. Hunt, can I ask you to present the report and the information we need? Thank you.
Yeah, good morning. I'm just going to read a paragraph from the executive summary that you've seen. So this report deals with the claim that a route running from Westbury Close to Robbins Lane should be included on the definitive map and statement. The report sets out the relevant evidence and legal tests, including the weight that can be given to that evidence to inform a determination or whether or not to make a definitive map modification order. So the subcommittee is required to assess that evidence and determine whether or not to make an appropriate modification order in effect to that evidence or to decline the application. In making the determination, the committee must base its consideration on the legal tests outlined in the appended investigation report. I believe obviously you've seen that and had the links to that. So yeah, I'll pass over to our consultant now who drafted and helped us to do the report on our behalf. She'll present and answer any questions you have in relation to that. Thank you.
Welcome to the meeting, Ms. Goodman-Jones, and nice to meet you. If you could take us through it then, please.
Lovely. Thank you, Neil. Well, it's lovely to meet you all. This is the first time I've presented to Glamorgan, so it's lovely to see you all. Hopefully you've read, there's a fairly detailed final report that was circulated. If you just give us 2 minutes, I'm basically going to be, it's going to be a fairly brief presentation highlighting the key points for anyone who's forgotten what's in the report or needs a refresh, and we'll take it from there. So just give us a second and I will share my screen.
Just while Ms. Goodman-Jones gets her presentation up, Chair, I'd just like to confirm for the sake of the recording and any observers this morning that obviously the subcommittee panel members have received all of the papers in relation to this item in advance with the publication of the papers. Thank you very much.
Right, can anyone see the slideshow yet?
No.
It's up on my screen, just bear with us. David, if there is a problem, would you be able to bring it up and I'll just talk?
Yeah, I can get that loaded in preparation.
That might just be a little bit quicker there, just to save. I did test it yesterday, but obviously you've got my presentation there. So if you just bring it up and then I can whiz through it. So while David's just bringing that up on screen, the case that we're going to be looking at is Westbury Close, Barry, Glamorgan. It was a definitive map modification application submitted in 2021, and the application was applying to add a public footpath to the legal definitive map and statement of public rights of way. My recommendation, you will note at the end of the report, if you've read the conclusion, is to refuse the application, and I'll run through the key points on the reasons for that once this presentation comes up. Any luck, David? Oh, yeah.
There we go.
Yeah. If you could just hold the first, can everyone see that?
We can. And would you mind going on to slideshow for us, please, David?
Yeah, just do start slideshow. That would be great. Thanks, David. I'm glad I sent that to you. So yeah, that was just Westbury Close is where we are. So if we can go to the next slide, we'll see. So this is, and I'll show you an aerial photograph for anybody who doesn't. I have obviously been on site. It was some time ago now. So the application, so we've got a route here mapped A, B to C. A is from Robbins Lane. A to B is through an area known as Robbins Court. And then C exits out onto Westbury Close in Barry, South Glamorgan. Quite a built-up area. Quite a lot of history to the site. When I first took up this case, the reason A to B is plotted a different sort of line style to A to C is the application map only came in plotting A to B, which kind of doesn't sort of ends in in the middle of Robbins Court. So I did ring up the applicant because just to clarify, and they did explain early in the stage that people had historically walked all over this site, but A to B to C, which joins Westbury Close, is what was described, and I could see that from the user evidence forms that were submitted to the application, and she clarified that yes, that was the main route that she was applying for, and that is the route that has been most used in time. So if we just switch to the next slide, it gives you a bit more context on the site. We've got an aerial photograph. So we've just got the line that sort of the applicant plotted here initially, but you can see Robbins Court, you can see kind of 1, 2, 3, 4, 5. They're actually sort of bungalows. They're part of sort of the newer development. And you've got High Glass area to the north there. So you can see from Robbins Lane on the right hand side, on the far eastern side, the route is kind of plotted. You can see there's kind of a wide verge, and it does actually cross turning areas, parking area. It's quite close to the boundary there, but it's clearly within that development. And then you can also sort of going northwestwards from the end of that dotted hash line, you can see a very clear tarmacked route going up to it's a bit obscured by the aerial photograph, there's a tree there, but there is actually a parking area there, a small parking area there that immediately butts onto Westbury Close. So that gives you some context. It's all in the report, but I am going to just summarise for the benefit of everyone here just a little bit of the history of the site, the legal tests, and why I've come to the recommendation to refuse the application. So next slide, please, David, that would be great. So just to recap, the application was made in 2021. 18 user evidence forms were filled in from individuals who claimed they had used the route. The predominant use mentioned on the forms was on foot. There was a little tiny bit of cycle and horse riding use mentioned, and I'll go into detail on some of the user evidence later, but the predominant use was foot. 15 of those 18 people had used the route for over 20 years, so a long time. And some of the evidence goes back as far as the 1960s, 70s, up until the sort of more recent times. Now, there is currently, I should have mentioned it earlier, there's really been no obstacles until a fence was erected near Point B. On the first map, I should have pointed this out, there was a little pink line at the end of that dotted where there is currently a fence in place, and has been a fence in place for some time now. And we'll talk about the fence and that as we proceed. In terms of land ownership, you'd see the section from Robbins Close. It's split into two different land ownerships. The council owned that sort of tarmac route you saw on the northwest section joining Westbury Close, and then through Robbins Court they also own a section, but there's another section that's mostly unknown at Land Registry. There's no registered landowner, but probably it's likely that the developer had something to do with the ownership in the past, but it's the leftover of a development basically. So if we can move to the next slide. And very briefly, I'm not going to bombard you with law. It's all in the report, but basically there's a few key tests that have to be considered with all these types of applications, and I'm just going to very quickly simplify that and make that very clear. So in terms of a user evidence case like this, so the applicant was just putting evidence of use. They weren't putting any historical map evidence, but I have obviously looked into that from my own professional basis, just to look at the history of the site and check some other documents. But from a user aspect, the process is all under Section 53 of the Wildlife and Countryside Act 1981. For a claim to be successful, there are some key tests that have to be satisfied, and it's all based on evidence and facts. It's nothing to do whether is this desirable, do people want it? That has to be excluded in the decision-making process, and I professionally have to exclude those understandable maybe reasons and comments, but for this purposes it's an evidential matter. So 20 years user test. There has to be 20 years clear uninterrupted use of a route. It does not have to be a specific time period. For example, it could be from the 1920s to the 1940s, the 1940s to the 90s. It doesn't have to be from a specific time. However, there's usually a challenge that kind of spurs on the 20-year test, i.e. an application in this case, which was 2021, or a fence in this case as well, which may have interrupted the use and brought the route into question. For a claim to be successful, the use has to be without force, without secrecy, and without permission. It has to be uninterrupted use, i.e. the 20 years have to be straight through. There can't be at year 10 an interruption, and there's no 20-year successful span. In addition, claims should always be public highway to be successful, i.e. a public road to another public road, or a public road to a public right, a highway of a lower status, such as a footpath, a public footpath, a public bridleway. There are some rare occasions, but they are very rare, where routes can go from a public highway to, say, a point of interest. But this is a very rare situation, has to be judged on a base to base. And there are guidance notes on that from the Planning Inspectorate, which I'll mention briefly as we move on. So next slide, David, we are getting there. So just to recap a bit of the history of this site for anyone who doesn't know this site. You could see that the first section was kind of an east, it was a kind of running straight across the screen there. Historically, this was going back to the 1960s, well, even the 1800s, but way back in history. This route used to extend westward. There was no housing development as there is now, to a location called Gibbonsdown Farm. I'll show you that briefly on a map, just so you've seen that. You've seen how the site was historically. So Kai Glass, which is just to the north of the dotted line, that was built around the mid 1960s, and obviously the bungalows there that are there just to the south of the line in Robbins Court, they're much newer in time as well. And I've looked at a few ordnance survey mapping, which kind of demonstrates that, and it's outlined in detail in the written report. But there are tithe maps and finance maps which don't say whether there's public status, but they do demonstrate the changes in time and how the site has changed. Recent consultations have been carried out, and I will talk about these in a little bit more detail just towards the end of the presentation. But to keep the flow, we'll move on just to touch on the user evidence, which is obviously key to this case, and whether there's been any interruption to the use, etc. So David, if you could move on to the next slide. So yeah, just to give you a bit of a picture there, sorry, of the history. We've got an 1880s Ordnance Survey map there on the left, and a finance map which is a bit later, 1910. You can see what I was talking about. You know, you can see Gibbons Down is marked on that left hand map. That kind of tracked pet line it just shows a physical feature. The FB footbridge has to be taken with a pinch of salt on legal status. It's just merely to demonstrate, and you can see that replicated on the map to the right, that there was an east to west route historically before all the housing development over time encompassed that area. The applicant did acknowledge that people may perhaps had used that as well, but that's not what the application was applying for. So there was undoubtedly probably some use of that, and there's a clear historical feature there demonstrated by those maps. So if we go on to the next slide. So the user evidence is obviously key to this case. We need to see, is there 20 years user evidence? Has it been, uninterrupted, etc., etc. So we need to see if the legal tests have been met. The purple bands there, you've got 1 to 18 on the left-hand side for the users. You'll notice that 3 of them there's no information. That's because unfortunately people didn't fill in any dates. However, their evidence has still been taken into consideration. Nevertheless, there are still 15 people there. You can see it goes from 1960 right up to 2021 when the application came in. There's a clear band. Most of the evidence seems to start around the 1990s. You can see a band. So that's a band of when people have said they've used it. So user number 13 has obviously used it for the longest period of time. So there is a very clear, the user evidence visually there shows there is very clearly way more than 20 years user evidence. So going back, yes, so if we can just, I can't remember what the next slide was, sorry, David. If we can just go on to the next slide anyway, and I'll start talking. So we'll talk about the fence. So the fence was mentioned. There was a little bit of a debate in my research about exactly when the fence was constructed. It doesn't really matter the exact date in this case because there's such a wide span of time when people use the route. The earliest that I've seen any aerial photographic evidence of the fence, there was a lot of different fences and construction and stuff that have gone on over time around Robins Court, but sort of half intersecting that route there. There's a little pink line on the map that I first brought up, and that's on page 2 of the report. You can see it's marked fence. There is a wooden fence there intersecting the route. It could have been back as early as 2015. Now, the 20 years test is taken back from the interruption. So whether you go 20 years back from 2021 or whether you go 20 years back from 2015, there is undoubtedly, it does meet the test. There is 20 years user test, and people have, up until the fence was constructed, there is no doubt from the user evidence that people did use it uninterrupted based on the evidence that was supplied to me. With the application, there is no mention of any other barriers, structures, etc. prior to those dates. However, there are 2 key legal points that I've had to consider as to why the application has failed. I haven't forgotten, I will talk about the consultation and some of the points people have raised as well, but the 2 key points as to why this application I have recommended not to make an order to add it is it fails to meet public highway to public highway. On the right-hand side, the east side of the map, you had Robins Lane. That is a publicly adopted highway, so that's fine. But Westbury Close to the northwest end, that is not, although it, for all intents and purposes, if you drove round, you wouldn't probably know any difference. It's a tarmac road, but legally and technically, that is not a public adopted highway by the council. So therefore, it fails on that key test. The other key test that it also fails on is the question as the use at public at large. Many of the use, it's quite a complex point, this one, but public at large, there are cases where, you know, especially in a built up area where many people will have used the route, especially for going to the shops, etc., recreation, which at this point walking the dog. And, you know, they are the local residents, but, you know, it's such a wide area that they could be classed as a public at large. In this case, it's such a, it's not like there's 56 people from all over Barry who've been using it. It's very, very contained to around the estate. And so it is questionable whether it does actually meet the test that this route is a public footpath for use at public at large. So hopefully that makes it very crystal clear as to why I have refused it. It meets very clearly, it meets the user test. There's no doubt people have used it. However, one of the key thing really is that it doesn't join a public adopted highway. Possibly people did continue on to, I can't remember the name of the street, O'Donnell, I think it is, to the north of Westbury Close. It might be off the map I've sent you, but there's Westbury Close does lead to a public adopted highway, you know, but the application was only describing it to Westbury Close as like basically a shortcut through for people to go to the shop, etc., just day-to-day recreation within that small area. So hopefully that's very clear. Now, there was a draft report and there has been quite extensive consultation on at various stages through the process. A large amount of information did come through. Yeah, that's the end of the slides, but I'll just very quickly, it's detailed. I'm not going to read everything because it's all been, I could have written a dissertation on the amount of information that came through, but I have summarised the consultations on pages 13 to 16 of the report. Most of those comments came from Robins Court Association or representatives. There was also the treasurer. So the majority of the bulk of the information responses came from Robins Court Association, which is that sort of little middle strip. The Robins Court is just below that dash line, those few sort of bungalows I mentioned there. There is a lot of information within the report. Some of it are genuine concerns of antisocial behaviour, fly tipping, just, you know, there's a lot of information there about antisocial, and I got that vibe immediately from visiting the site. That has been some problems. However, as you remember at the beginning of this report, this is an evidential and factual matter, and you have to, I have to, and also as decision makers have to remember that whilst that could be managed, if you know, my recommendation was to recommend, that would be then a management issue for the future. But in this case, I've obviously recommended not to, but it's just to bring up that there were genuine concerns about that, but legally, technically, there's something I cannot take into account because that's not what the very specific legal tests you have to look at. As I say, there's a lot of information. There are some questions about historical procedures with the council, with notices and information and landowner contact, etc. But that has been dealt with already by, I can't remember the exact date, but by the planning inspector have already dealt with that. An ombudsman has already dealt with that and is satisfied that the council did historically follow correct procedures. There are some brief comments from utility. They have no issues. Bridleway, Bridle Trust had no issues. There was a member of the public that actually wanted it recorded. Actually, there was two comments about actually wanting to support it being a public right of way. Obviously, we have to go back to the legal tests, and desirability can't always come into this, I'm afraid. So obviously that's why I've made my recommendation based on the legal test. There was also a landowner who responded, who lived very near abutting the claimed route. He also mentioned antisocial behaviour, some overgrowth as well, and it was challenging that. There is a bit of a contradiction there with the evidence that I've been provided with in terms of what people have used. But nevertheless, as for the reasons I've explained, despite the fact that there has been extensive use, there has been an interruption as well with the fence, etc. It still fails primarily because it doesn't join a public adopted highway, and there's a question about the public at large as well. Hopefully that summarises the key points for you as succinctly as possible. I'm not sure now if any councillors or the chair has any questions. Is now the right time, Amy? Or David, I will hand back to you.
Yes, thank you, Claire. Yes, I think what might be best for us to do is bring in Mr. Ali at this point as our public speaker, if that's all right with yourself, Chair. And then obviously when we go to debate, then if there are any questions for yourself, Claire, the committee can raise those at that point.
Okay, so Mr. Ali, yes, that's fine. I'm happy.
Right. Can I invite Mr. Ali to come on screen then, please?
So, Mr. Ali, if you wouldn't mind pressing the camera symbol and the microphone symbol for us, usually in the top right-hand corner. Oh, there, that's lovely. We can hear and see you now, Mr. Ali. You do have 3 minutes. Your time will start when you begin to speak. And please take it away.
Yes, first of all, good morning to everybody. My name is Hussein Wayne Ali, and I am the representative of Robins Court Residents Association. On behalf of Robins Court Residents Association, we welcome Birchill Estate Consultancy's recommendation in the final investigation report that the council declined to make an order and record the claimed route a public footpath on the definitive map and statement. We also welcome Mr. Hunt's approval of the Birchill recommendation in his cover report and the Director of Place signing it off. There are, however, elements of the report that we do not agree with. Obviously, I haven't got time to go into detail, but I just wanted it to be recorded at this meeting that we don't fully agree with the content of the final report. The reasons for declining to make an order set out in paragraph 9.1 are compelling. We would add that Westbury Close is a local authority development, so the landlord for the tenants is the council. It is a fact that tenants cannot claim a public right of way over land owned by their landlord. It follows that the providers of user evidence forms that are or were council tenants cannot claim a public right of way over the application route because other than about 2 meters or so of length behind number 10 Kite Glass, the land in question is owned by the council and allocated to its housing department. We trust that the PROW committee will accept the recommendation and determine that an order not be made for this application. Thank you very much.
Thank you, Mr. Hussain. If you just stay on screen for a few seconds in case anybody would like any clarification or any of the points you've raised, any of the members of the committee. I see no hands, so I'm assuming that that's everyone's happy with what you said. If you'd then like to go off screen and mute yourself, we'll move on with the meeting. Next in the procedure would be any councillors available organ not on the committee who may wish to address the committee. I don't see any hands. The only person I think of relevant to that would be Councillor Charles, and she's not got a hand up. in that case, we move on to those supporting the application. There are none of those. So I'll go back to Mr. Hunt. Janice, you come on screen. Did you want to speak?
No, I didn't, but thank you.
Thank you. Those supporting the application, sorry, gone beyond that. We go back to Mr. Hunt, who may comment on the representations made.
Yes, so in the context of this meeting, Chair, that would be Mr. Hunt and Ms. Goodman-Jones.
And Ms. Goodman-Jones.
Yes, through the debate, whether or not the committee have any questions.
So, well, I mean, the next thing, the responsible officer may comment on the representations made, and then we've got the questions and the debate. So, David, do you have anything to add to what's already been said, or can we just carry on with the debate?
Yeah, nothing further to add from myself. No.
Yeah, Claire?
No, I have no further comments to make. I take on board the extra additional points that they raised. The key facts are still there in my report, and that you needed to consider. So yeah, and there is no objection. So
thank you for that. In that case, I invite members of the committee to ask questions and comment. Eddie, Councillor Williams.
Yeah, thank you, Chair. Really, I suppose the one question, I recognise the tests and the reasons for fail, and one in particular was the public highway to public highway. It's currently unadopted, so therefore it doesn't meet the test. I'm just curious as to whether is that likely to happen in the future. I recognise that because the application is before us at this moment, we have to take it as it stands. But I was just curious as to whether is there a likelihood that at any point that the highway would be adopted? Westbury Close.
So I will answer that first, and then David might want to comment as Glamorgan County Council. I'm not the Highways Board. Obviously, if you should approve my recommendation and move forward, that doesn't prevent any future application coming forward, whether that's on the same alignment or on a different alignment. That's entirely something for the future and have to be considered separately. Obviously, as a highway authority, you can adopt highways and adopt highways as under your own remit, and that's probably something that David would have to comment whether is likely or not. I wouldn't know from that would be some local knowledge whether that's. I have not heard news of that, whether that's likely or whether you're just asking the question hypothetically, presumably, and then perhaps David could add further to that. David.
Yeah, as Claire said, it's perfectly feasible. It could well become adopted in the future, but that would be a decision for the Highways Department to take. And yeah, I've had no discussion along those lines. So at the moment, yeah, just as it stands, that would have to be taken up with Highways if they wish to do so.
Thank you, David. Welcome to the meeting, Nick. Eddie, you've got your hand up again.
Yeah, thank you for that, and I just needed that to be said so that we're clear. And the point that Claire has made regarding that, should the circumstances change, then maybe that could be brought back, recognising that there is another reason for a failed test. But I just wanted to make sure that that we were aware of that and that's been covered. So thank you for that.
I see no other hands up. I actually have a question. I recognise that this isn't germane to this issue, but and what's the justification for the fence? Does anyone know why this fence was erected across what appears to be a traditionally used pedestrian way?
Yeah, so bear with us, Neil, because it is some time since I looked at the case and I've seen the fence on site, and I remember sort of talking to some of the residents in Robin Court, which is a very enclosed area, and there were lots of, I can't remember the exact detail and the reason for the fence off the top of my head. But it was, they were doing works in that area, obviously, to construct Robin's Court, which is quite a new development compared to Kai Glass, which was built around the sort of 1970s. I think that was finished, and obviously all around it was developed. So Robins Court was really the last bit of development in that area. So I am assuming the fence was something to do with that. There obviously has been comments about antisocial behaviour in the past, and I think it was just to make it a private sort of development and exclude it off from the rest of the area. That's the, I can't say that's exactly the reason, but yeah, that was the impression I got from talking to residents. I don't know if I doubt there's anyone else here who can comment on that, David, unless you've got anything else.
No, that's pretty much my understanding. Yeah.
Yeah, I as I said, I think it's probably not germane to the matter in hand, but it was just be speculating on what could be going on there. In that case, we have all the evidence in. I'm assuming from Eddie, you have your hand up.
Yeah, on the basis that there aren't any further questions or discussion, I'm happy to move the recommendation for refusal.
So I have a second for that. Thank you, Pam.
I'll second that, Chair.
Yeah. I'm assuming as there's no hands up and no comment from anybody else that everyone's content with that motion and that therefore the refusal stands.
If I may, Chair, just for the sake of the minutes and the recording, just to note, obviously, that Councillor Hodges was not present for the entirety of the item, so therefore he is not voting in this matter. But obviously, the vote has been taken by no dissent.
Yeah, and it's quorum that 4 members were present, so
yes, yes, Chair, you were certainly quorum. And if you wouldn't mind, I'd just like to mention that Councillor Hennessy has also joined in observation.
Okay. Welcome, Andrew. All right, in that case, thank you very much for that. Moving on, thank you for your time, Claire, and moving now on to the next matter, which is item 7, agenda item 7, which is the application for modification of definitive map and statement, Wildlife and Countryside Act 1981, section 53(3)(c)(3), to delete the full extent of the path 73, Barry, as recorded on the definitive map. And again, Mr. Hunt, can you take us through this, please? David.
Yeah, right. So yeah, just read through the summary like I did for the last one. So this report deals with a claim that the route running from the southwestern end of the adopted highway at Closcombe Barry through to Porthcurry Country Park at the edge of Mill Wood, known as footpath 73, should be deleted from the definitive map and statement. So again, the report sets out all the evidence and tests, including the weight that can be given to that evidence to inform a determination of whether or not to make the definitive map modification order. So again, I'll pass over to our other consultant, Deborah, who will take you through the report and questions on this one. Thank you.
Good morning, everybody.
Welcome.
My name's Deborah. Thank you. My name's Deborah Sharples. I'm a solicitor, and I've been appointed by the council to consider the evidence for and against this application, which includes all the information provided by the applicant, and to give the council my opinion as to whether the application should succeed or not. That opinion is then considered by the officers who've made a recommendation to you. The decision obviously ultimately lies with the committee members. All I can do is make a recommendation and give you advice. To that end, you've been provided with a detailed report, and you also have had access to a very significant amount of information and evidence provided by the applicant. As far as the evidence goes, part of your decision is for you to decide what weight you place on individual items of evidence once you've accepted that that particular item of evidence is relevant. But I can offer you guidance as to the factors which affect that weight. So the application, as you've heard, is an application to delete footpath 73 from the definitive map. That means that if you make the order, the footpath will be removed from the definitive map, and if you don't make the order, it will remain on the definitive map, subject obviously to any appeals that are submitted. So footpath 73 is shown on the plan, which is at the beginning of your committee report at paragraph 1.2. It runs from A to D. It's also shown in a little bit more detail in document 3 of the documents which you have provided to you. From A to B, footpath 73 crosses a private driveway. So that's land owned by private individuals, which gives access to their houses. And from B to D, it crosses Porthcurry Country Park, which is land owned by the Vale of Glamorgan Council and is open to the public for recreation. Footpath 73 was added to the definitive map in 2003, following an application made by a member of the public in 1999. The order to add it to the map was originally made by the council in 2002, and that was confirmed by an inspector following a hearing in 2003. At that hearing, the inspector heard evidence from witnesses and saw various documents, including plans and aerial photographs. He had the opportunity to question witnesses, and he undertook a site visit. The reason that he chose to add or to confirm that the footpath should be added to the definitive map was on the basis of user evidence. I have set out in the report for you, as a reminder, the tests for adding rights of way to the definitive map on the basis of user evidence, and you've had a little refresher on that already this morning from Miss Goodman-Jones. As a result of the evidence that the inspector heard and saw at that hearing, he ordered that it should be confirmed because he felt on the balance of probabilities that the footpath existed. He based his decision on evidence of use over a 20-year period from mid-1979 to mid-1999, and he was satisfied that the route had been used by the public as of right and without interruption during all of that time. He was also satisfied that the landowners had not taken any step to bring it to the attention of the public that there was no intention on their part to dedicate the right of way, and there had been no challenge to the use which prevented the right from being acquired. His decision letter is document 90B in the bundle of documents that you've got in front of you, or available to you at least. The question of whether the footpath should be deleted was considered by the council again in 2009, following two applications, one by Mrs. Underdown and one by Mrs. Medhurst. And again, the council refused to remove footpath 73 from the definitive map. So the matter was appealed, and an inspector considered the issue again in 2011. His decision letter is document 125. He was effectively considering the same question which you are now considering. That question is, since the decision was made to add the route to the definitive map in 2003, has any new evidence been discovered which, when considered with all the other relevant evidence, shows that the public right-of-way should not in fact have been recorded on the definitive map and statement, i.e. should it now be deleted? And that's the test set out in paragraph 50, section 53(3)(c) of the Wildlife and Countryside Act. It's in paragraph 2.4 of your committee report, but unfortunately it's labelled as 53(3)(a), but that's a computer correcting the numbering system error rather than anything else. So it is just to note that is the test in C, is the one that you need to be looking at in paragraph 2.4. Similarly to the advice given to you by Ms. Goodman-Jones, you can only consider the information, the evidence and the information and the test which the statute allows you to consider. So it's new evidence discovered since it was added to the definitive map and which has not previously been considered by a decision maker in relation to the question of whether this route should be on the definitive map or not. This is not an opportunity to reopen the decision that was made in 2003 and the decision that was made in 2011, and to simply re-examine again all that evidence and to consider whether the inspector was right or not. There must be the discovery of new evidence before you can have the opportunity to reconsider the matter. There is criticism by the applicant in the application of the process and the procedure and the motives and the competence of the decision makers, which led to the decision in 2003. That's both council decision makers and the inspector. But none of this is relevant to your decision now, and you can't take it into account. Schedule 15, paragraph 12 of the Wildlife and Countryside Act 1981 specifically says that the validity of an order can only be challenged within 42 days of the notice of the order being given, and then only by an application to the High Court. So it is now much too late to bring any sort of criticism of the process and procedure in 2003. And this was made clear to the applicant by the inspector in 2011, who in paragraph 12 of his decision made reference to that statutory provision and his view, which agrees with mine, which is that it now is excluded. And the passage of time is such anyway that it would be well out of time for any sort of challenge. The inspector in 2011 has also set out in his decision letter various points about evidence, and I agree with all of those points, and I just mentioned them to you now. The first is that case law is not evidence. There's been some mention of a case called Fernley, which the applicant says wasn't correctly considered at the meeting in 2003. However, it was considered. It was a historical matter whether it was considered correctly or not, and the inspector in 2011 made that point. I don't particularly think it's relevant in any event, and it's certainly not relevant now. You cannot take into account personal considerations, so you can't take into account whether this footpath is causing inconvenience to anybody, whether anybody feels injustice about the footpath or about the way they have been treated. You may well sympathise with Mr and Mrs Underdown, who have this footpath crossing their land and object to it, but you simply can't allow that as a matter of law to influence your decision. And the inspector in 2002 made this very clear in paragraph 35 of his decision letter. I'd also like to remind you, an important point from the report, that the presumption in the case of a deletion is that the route was correctly added to the definitive map in the first place. This means not that you can't delete it from the definitive map, but that in order to delete it, you need evidence of some substance to counter that. The assumption being that it would not have been added to the definitive map in the first place if there hadn't been evidence to cause it to be added, and therefore you're looking for something now which has enough weight to counter that, the fact that it was added in the first place. The test is only the balance of probabilities. So in other words, you have to think it is more likely than not that it should be removed from the map in order to remove it. But on the one side of the balance is the fact that it was there in the first place, with evidence having been heard. So you need something on the other side which has similar substance to that. We were also reminded by the inspector in 2011 that you can't know now the full scope of the evidence that was heard by the inspector in 2002. It's too long ago to know exactly what he heard and what he took into account. But that he, on the basis of that evidence, considered it should be added to the map. You have been presented in this case with an awful lot of material, and a lot of that material I would assess as not being evidence at all. So, for example, opinion is not evidence. My opinion isn't evidence, and the applicant's opinion isn't evidence. But, and indeed the expert opinion on the photographs isn't evidence. But all of those opinions are things which you can listen to and take into account in helping you to reach your decision. And it's for you to decide whose opinion you think is right based on your knowledge and experience, and your knowledge of the people and their status, I suppose. Case law, as I mentioned, is also not evidence, but it may assist you, or it will assist you, to know how much weight you can give to the evidence, and what evidence is relevant, and how that evidence should be applied. The applicant's interpretation of events and assumptions as to motivation and other feelings and thoughts of individuals involved in this matter are also not evidence. In fact, the motives of the parties throughout this process are not relevant to the question which you have to decide. There are many allegations of wrongdoing by various parties in this, but the inspector in 2011, in paragraphs 96 and 97, made it clear that those can't be taken into account. The only things you can take into account here are factual matters about whether there is now evidence to suggest that the footpath was not one which should have been added to the definitive map. There's also been an allegation that the footpath was incorrectly laid out after the order was confirmed. That's not relevant. That's a post the event matter, and the applicant has accepted that. So I have set out in the report the background to the development at Cumbarry, at the paragraphs that are numbered 4 point something.
I'm sorry, Ms Sharples. I'm very sorry to interrupt. Can I just check that Councillor Drake, I believe we lost you momentarily. Are you able to hear and see us? I'm afraid you're muted, Councillor Drake.
Well, it was only a couple of seconds. Unfortunately, my screen just switched off.
That's okay, no problem. I just wanted to check you were here. Sorry to that. Yes, thank you. Apologies, Ms Sharples, if you'd like to continue.
Absolutely fine. I did see somebody disappear off the screen, but wasn't sure who it was. So I'm glad you've confirmed that. So what I was saying just before I think Councillor Drake disappeared is that the allegation that the footpath was incorrectly laid out after the order was confirmed is not relevant. It's a post, a thing that happened post the event, and the applicant has accepted that. So I've set out in the report the background to the development at Cumbarry, and that information is in the paragraphs that are numbered 4 point various things in my report. But I've put that in there by way of context only. In my strong view, it isn't relevant to your decision now. That's all historical events. It doesn't really matter how it came about that there was a route there or a claim there. It doesn't matter whether the Section 106 agreement was followed through, should have been followed through or not. What matters is, was the route used by people or not, or more accurately now, is there now evidence that it was not used and that the inspector was wrong, and that evidence has to be a sufficient weight to override his decision. So Mr. and Mrs. Underdown and the applicant are critical of the council, the councillors, Taylor Wimpey and others for their actions at the time when the development was developed, in particular in relation to the Section 106 agreement and a proposed access to Porthcurry Country Park. But none of that provides any relevance with respect to the right of way. And as importantly, or perhaps even more importantly, it was all considered by the inspectors in 2002 and 2011. What we do know, however, is that no public right of access was ever granted over the route of footpath 73 by virtue of the Section 106 agreement. What that means is that anybody who was using it was not using it by virtue of a right to use it given to them by that agreement. They were using it as of right rather than by right. Imagine you're all familiar with the concepts of as of right and by right. So in order for a route to be claimed by use by the public, they have to be using it as if they had the right to use it and not because they had the right to use it. So I have set out in the paragraphs numbered 6 in the report the case assessment, which is the assessment I have made of the information and evidence that's been put before you. And I've said in that why I think various elements are not relevant, what I think is relevant, what I think you can and can't take into account. I don't propose to go through all that now because there's a lot of it, and I think if it's presented to you already now, that potentially just becomes an overwhelming amount of information. But I have identified 2 significant items which have been submitted that I think could be considered to be newly discovered evidence, and newly discovered evidence is what you are looking for in making this decision. So those 2 items are some aerial photographs and a report by Mrs. Cox, which was submitted later than the other evidence, and a reservation of rights over 6 and 8 Closs Cumbarry, that were dealt with at paragraphs 6.17 and 6.24 of my report. So the aerial photographs are certainly the type of material which might be evidence. Mrs. Cox has given in her report her opinion as to their meanings, and you should apply your own judgment to whether or not you agree with her. She says that these photographs show that there's no evidence of wear on the route of footpath 73 between 1979 and 1999, and draws the conclusion from that that the route couldn't have been used and that the inspector must have been mistaken in his decision and therefore it should be removed from the definitive map. However, I think the first question that has to be asked is this evidence in fact new evidence? And I would suggest that it is not, or it very largely is not. And this is because both inspectors considered aerial photographs previously. In the decision letter from 2011, they're referred to very specifically at paragraphs 58 and 59. And in the report from 2002, they're referred to at paragraph 31. And the inspector in 2011, I think importantly, accepted that there was little or no evidence of wear on the route, but he did not accept that that indicated that there hadn't been use. And he also said that although he couldn't see a gap in the hedge in the appropriate place for footpath 73 on the photographs, he couldn't say with certainty that a relevant gap in the hedge did not exist or that people didn't make their way through some sort of gap in the hedge in order to use the route. I agree with his assessment of the situation. You have a situation where an inspector has not only seen some aerial photographs, but has also heard the live evidence from witnesses, much closer to the time of the claim than we are now, and has taken the view that he accepted that the people who said they were walking the route were in fact walking the route. It is possible, well, the inspector in 2002 said that he felt that there had been urban fringe encroachment on the land from 1979 and it had grown over the years. And it is possible for a relatively small level of use to be enough to establish a claim. And it is equally possible that that just isn't discernible from an aerial photograph. A lot will depend on the weather and various other factors. So I see no reason to question the approach of the inspector in 2011 as far as aerial photographs are concerned. And it is my view that there is nothing new in these photographs, and to the extent that there may be anything new in these photographs, it's not sufficient to outweigh the presumption that the inspector at the time heard evidence that gave him reason to think it was used. The second item of evidence that I believe I found relates to this reservation of rights over 6 and 8 Closcombe Barry. Unfortunately for you, perhaps, this is quite a heavily legal point, but I've set it out in some detail at paragraphs 6.17 to 6.24. It's not something that was raised by the applicant, but it's something that I identified when I was looking at the title deeds to the various properties, when I was considering a point that was made by the applicant, which was that in her view, the use of the route had been by way of a licence passed on to occupiers of the houses by the developers. The argument put by the applicant was misconceived. That licence that the developer had for rights of way was not passed on to the owners of the properties. But I did identify a different and I thought better argument in favour of deletion. This argument was that some of the users who gave evidence that they were using the right of way prior to 1999 did so because they had a private right of way granted to them as occupiers of properties on part of the development. This is significant because of the point I mentioned before, the by right as opposed to as of right point. So to the extent that they were walking on that route in exercise of a private right of way, that would not have been enough to create a right of way. And this is something I felt was not put to either of the inspectors and needed therefore to be considered. So as I say, this is set out in 6.17 onwards of the report. And what this essentially said is that the owners of properties in phase 1 and phase 3 of the development at Cumbarry had a right to pass and repass along part of the access ways coloured in blue on the plan, and that was to allow them to gain access to parts of the estate. The estate was defined as phase 1 and phase 3 of the development, and the area coloured blue over which this right-of-way could be exercised, in this case, included the driveway over which footpath 73 runs. So this meant that the people who owned properties in phase 1 and phase 3 of the estate were entitled to cross the shared driveway in order to access 6 and 8 Clos Cumbarry and to access the boundary wall of 9 Clos Cumbarry, but not exercising that private right to access Porthcurry Country Park, because Porthcurry Country Park was not part of the estate. However, when those same people, and this is a bit of an oddity, when those same people were coming back from Porthcurry Country Park, they did have the private right to cross the driveway because they were then accessing part of the estate, i.e. going back to their own house within the estate. So I had to ask myself, is this new evidence that changed everything? Because the inspector had assumed that there was no private right over the access way. I've explained the scope of the right. In other words, that sometimes these people would be exercising the private right and sometimes they wouldn't. But also it only applies to those people who have houses in the relevant parts of the estate. So any users who came from somewhere else in the estate or came from outside the estate entirely were not exercising any sort of private right. So I think I'll read you 6.22 of the report. The evidence thus means that the return journey of some of the users from Porthcurry Country Park to the development would have been by right. This, however, makes only a small difference to the claim because it would have been, and clearly was, readily evident to the owners of the land crossed by footpath 73, as it would have been to any reasonable owner, that all users walking from the development towards Porthcurry Country Park were using the route as of right and not by right. In other words, their use was potentially able to establish a claim, and that a proportion of those coming the other way, those who didn't live on phases 1 and phases 3, were also using it as of right and not by right. This level of use by the same number of people would have been sufficient, in my view, to bring it to the attention of the reasonable landowner that a public right-of-way was being asserted. To cause a change to be made to the definitive map and statement, new evidence must be substantial, and not only any small piece of evidence will be sufficient, and that's the case of Trevelyan. In reaching this conclusion, account has been taken of the fact that the inspector in 2002 considered not only user evidence forms, but also heard oral evidence and saw other documents. He saw a letter from Mr. and Mrs. Beatty at number 6 Clos Cumbarry, indicating that in July 1999, as soon as they moved in, they put up signs indicating that the route was private and not a footpath for access to the field. That's an indication to me that there was a noticeable degree of use by the public at that time, which Mr. Beatty understood to be outside the scope of the private right, which had recently been included in the transfer of the property to him. This is document number 123. Mr. and Mrs. Underdown also wrote of having experienced some disruption by people wanting to cross our drive to gain access to Porthcurry Park as it is, and that's document number 124. None of which are have we recognised to be our immediate neighbours. It suggests to me that both of these owners, having recently moved in, having recently seen their title deeds, would have been aware of the private right existing, and they were experiencing a use that went beyond that, in their opinion. The owners of the shared driveway later placed gates across the drive to show that it was not a continuation of the pavement to the fields. In the same document, they referred to users who lived 7/10 of a mile and 6/10 of a mile from the site, in locations not within the development. This all suggests that there was evidence of use from people other than those who benefit from the rights of way reserved. For those reasons, I think that even if the inspector had known in 2003 about these reserved private rights, it would not have reasonably made any difference to his decision, and therefore I don't see it as being new evidence of sufficient weight to cause this right of way to be deleted from the definitive map. So my conclusion is that this was new evidence.
Excuse me.
Oh, sorry. So I think it was new evidence. I think it's not previously been considered, but I don't think it justifies the deletion of the route from the definitive map. The other factors which have been raised by the applicant, I've addressed in detail in the report, and I don't propose to take you through them now, but I will be happy in due course to answer questions on them. But in summary, my advice in relation to all of those is that they are either irrelevant matters, or they're matters which have been previously raised and considered, and therefore they're not new evidence.
Thank you for that, Deborah. I mean, it's worthwhile drawing attention at this moment to the fact that along with the papers we've received, there are 132 documents referred to in the report which you have access to. Plus, we have had late reps over the last few days from the applicant.
Yes, and sir, I have read those late representations to make sure there was nothing in there which changed my view, and I found nothing in there that was new.
Thank you, Deborah. Right, moving on then, we come to any councillors of the Vale Council not on the Public Rights of Way Committee who may wish to address the committee. I see no hands and no one coming up. In that case, we move on to public speakers in support of the application. And I believe, Mrs. Medhurst, you're the first of those, if you'd like to come on screen. And unmute yourself. There you go. You have 3 minutes, as explained by Amy earlier. Go on.
With respect, Chair, I think I go last as the applicant, that Miss Chris Cox should go first. I'm the applicant, so I'm the last to speak according to the procedure, to my understanding.
I just have a list of speakers in order, for or against, and you are for.
But I'm the applicant.
Yeah, in that case, I don't mind if Ms. Cox would like to go before you, then I'm happy with that. So if you'd like to go off screen again, please, Mrs. Medhurst, I'll invite Ms. Cox to come on. You have 3 minutes, Ms. Cox, as explained by Amy. I'm sure it's starting when you start.
Thank you. Good morning. I presented my expert evidence from aerial photographs on behalf of the applicant, I believe as report 132. Now, the 2023 investigation report with respect states at paragraph 6.47, the photographs are being used to try to show there was no use of the routes at the times when photographs were taken. With respect, the photographs are physical evidence that show no use during the statutory period. In answer to paragraph 6.47, the aerial photographs are not being used to try to show no use, or indeed to try to show anything. They're being used to provide objective expert evidence for or against alleged use under the objectivity requirements of Civil Procedure Rules Part 35 for experts. These rules demand complete objectivity backed by direct evidence delivered by a recognised and qualified expert in the relevant discipline. No formal expert evidence report has previously been provided to either planning inspector, who have drawn their own non-expert with respect conclusions, or to a subcommittee of planning. A planning inspector is an expert in planning, not aerial photographic interpretation. Both inspectors note no evidence from aerial photographs for linear access along the alleged route prior to the layout of the roads for the development late 1990s prior to 2000. Before this time, Point A was simply a point in the agricultural landscape with no visible evidence on aerial photographs for external pedestrian access to or from it. I agree that the change in visibility from 2000 is in accordance with the change of land use of the north part of the site from wholly agricultural to residential recent to that date, and the footpath, as opposed to agricultural use, actually dates from the time of this change from pastoral agricultural to residential land use. Just one moment, please. I'm busy online, thank you. These are important and relevant points made in the council and both previous inspectors' reports, which merit and require detailed joint consideration by the aerial photographic experts for both sides in this case. These points include, but aren't all, agricultural land use of the land and specific traces of that use on aerial photographs, and the proven use of aerial photographs to provide evidence for residual and past land use, not simply use on one moment in time. And this is something I'd like to discuss in detail, possibly later. Therefore, aerial photographs provide a robust and important element to assist this case. I respectfully disagree with some of the findings of the 2023 investigation report.
That's 3 minutes, Chair.
Thank you.
Yeah, I'm sorry,
I request a meeting of experts, which in this case, with respect, will be a meeting between myself and the council officer.
Ms. Cox.
Thank you.
If you'd stay online, if there are any quick points of clarification that anyone would like to raise from the committee. I see no hands up. I do have a point of clarification. I would assume that aerial photographs would normally demonstrate heavy land use where there is wear and tear on the grass and so on, but they wouldn't show more sporadic or less frequent land use where the land has time to recover to a degree between passages of people going across.
I would actually disagree with that, given in this particular instance with the nature of the environment. I feel that past land use would show as well, and I feel that more sporadic lighter land use may well be evident in terms of wear over areas of access and areas of access. So I cannot agree with that totally, with respect.
Thank you very much. In that case, there being no other further points of clarification, Ms. Cox, if you'd like to go off screen and mute yourself.
Of course, thank you.
Thank you very much for your time. I now invite Mrs. Medhurst to return, come on screen and mute yourself, and you two have 3 minutes.
The alleged defamatory content in my submissions has not been proven by the council, but para 4.19b remains in the report for the public at large to access. These facts and the unwarranted redaction in the report and the late reps means I will not be addressing the report per se. The reasoning in the Westbury Close report recommendation to decline to make an order is analogous to footpath 73. I quote, "The fact that Westbury Close is an unadopted road and may not have public access rights does have a significance. When the order for footpath 73 was made, Closcombe was an unadopted road with no proven public access rights to order point A. Access along Closcombe to order point A was limited to phase 1 and 3 residents, whose conveyances granted them the rights to pass along unadopted estate roads. They had no rights to pass over the private drive serving 6 and 8 Closcombe. Use of the private drive by uninvited residents was therefore by force because it breached the terms of their conveyance. Of the 17 witnesses supporting the original application, 12 lived on phases 1 or 3 and 2 were related to a phase 1 witness. The remaining 3 lived off site, but their evidence was never tested. Had the same legislative context been applied, the original Closcombe application, as in the current Westbury Close claim, an order would not have been made. As to order confirmation, Closcombe was erroneously described an adopted highway. Section B to D passed over PCP, where public recreational rights had subsisted since November 94, and no public access was available at Order Point D until November 94. Order Point A was a cul-de-sac for the entire statutory period relied on, and Order Point B for most of it. So it was impossible for a way to subsist connecting these two termini. A Closcombe was missold by Wimpey as a private dwelling in full knowledge as residents were petitioning to use the property as an entrance to PCP. The footpath never subsisted. It was added to the DMS to serve as an entrance to PCP and to cover up breaches of planning control, the Section 106 and Wimpey's contractual obligations. The law and truth must prevail, and an order made to delete footpath 73 from the DMS. I would just add, if Claire Goodman-Jones had done the report, her recommendation would have been to delete footpath 73. Thank you for listening to me.
Thank you very much, Ms. Just stay on for a few moments to see if there are any points of clarification from any of the members of the committee, subcommittee rather. I see no hands. In that case, Mrs. Medhurst, if you'd like to turn off your camera and microphone, we'll carry on with the meeting. I think we now go back to you, Deborah and David, for your comments and to allow councillors to ask questions if they wish. Deborah,
would you like me to comment on Mrs. Medhurst's
on the two submissions we just had? Yeah.
Mrs. Cox has given her opinion as to the meaning of those photographs. She is an expert. I have no reason to think she isn't an expert, but it remains for you to make your judgment as decision makers as to your interpretation of them. They were, what I would say is, aerial photographs were previously considered, and new evidence is what you're looking for. As to Mrs. Medhurst's submission, I don't agree that if Miss Goodman-Jones had been making this advice, she would have making this report, she would have come to a different conclusion, because whatever she says about a footpath having to go from public highway to public highway, the facts were known by the inspector when he made the decision in 2003. They were known by the inspector when he made his decision in 2011, and therefore they are not new. And therefore nothing about the unadoption or the fact that Closcombe hadn't been adopted in 2003 or 1999 is relevant. I also don't accept that adoption is the same thing as the existence or non-existence of public rights of way over a road. Adoption is about a road being maintainable at public expense. It is plainly obvious that there were public rights over the access roads in the estate before adoption. Otherwise, how would people have had their rubbish collected and their furniture delivered and all the rest of it? It's not just the people on the estate who are able to come and grow on those roads. It is also not the case that people living on the estate had no rights over the driveway of Closcombe. I've explained to you the extent to which they had those rights, but it's just a matter of law. Whether number 8 was missold or not is not relevant to your decision. It's something from a long time ago, which would be something which would be dealt with by a completely different mechanism to this. Your decision has to concentrate, and you have to bear in mind only those things which are relevant, which is new evidence not previously considered, which would change your view as to whether the inspector made the right decision or not in 2003. It's not an opportunity to simply go over the evidence that the inspector considered and ask yourself, was he right or not? You may well say he wasn't right, but you have to ask, is there new evidence that suggests he's not right? And my advice to you is that I haven't found any.
Thank you very much. David, do you have anything to add?
Nothing further to add from me, no. Thank you.
Fine, thank you very much. Right, committee, we have the opportunity now to ask questions or ask for explanations and to voice our views. Does anyone want to make a contribution to this? Councillor Bruce.
Yes, just an observation, really. How do the neighbours feel about it? Because, you know, if they're going past their homes as well.
We have evidence within the documents that the big document package that certainly the resident of number 6, I believe, has the ownership of that has changed hands, and where previously the owner was opposed to was in favour of the application to delete, the present owner is opposed to the application to delete. He wants to keep it. He likes it. He finds it help in his submission. I think he said he finds it of good therapeutic value for himself and his family to be able to access the park right next door to them.
Lovely. Yes. Thank you.
Councillor Charles has got a hand up. Are members of the committee happy for her to speak? Yes. Janice.
Thank you, committee, and thank you, Councillor Neil Thomas. Yes, the people next door, actually, I am the ward member for that area. The people actually bought the house knowing that the path was there and they had easy access to the park through it. It is used often by many people. I have had people come to me for support in keeping it open, and I just wanted to update you on a bit more information on that. That's all.
Thank you very much, Jan. You put your hand down now. Are there any other members? Right, Councillor Williams, you have your hand up.
I did, Chair, but if it's Deborah wants to speak first, then
in that case,
comment. Thank you.
Yeah, Deborah, you did put your hand up. You're muted.
Easy mistake to make. I just wanted to remind the committee members that the desirability or otherwise of this route isn't material to your consideration. So the fact that people want to keep it is no more relevant than the fact that the Underdowns would rather it went away.
Yeah. Thank you for that timely reminder. It is a matter of evidence rather than a matter of opinion or whatever. Eddie, can I ask for you to? You've got your hand up there.
Thanks, Chair. It clearly is a difficult one because we've got to some extent, we've got recognising that we can't take people's views, wishes and desirability and etc. If I was somebody who's going across the front of my drive, I wouldn't be happy with that. However, with the evidence and the way that it's been presented, it's clear that it's from Deborah, this isn't new evidence. And unfortunately, although the properties, the people in those properties, they were already aware of what the rights were. So it's unfortunately for them, but as it stands at the moment, I'm going to accept that the decision made previously that it is a public right of way that should stand, and therefore I would move that.
So you're moving the recommendation, which is to decline the application.
Yes, Chair.
The order should not be made.
Yeah.
Do I have a second for that? Thank you, Councillor Drake and Councillor Bruce. In that case, unless I see dissent, then that appears to be by full agreement. I see Councillor Hodges nodding his head. I agree too. In that case, the order should not be made. Thank you all very much indeed. And thank you for your time. Eddie.
Chair, I would like to thank the experts who have provided additional support to us for this complex. And as you said, there's the amount of material that was presented provided some challenges. However, it's been presented in a way that we can come to this conclusion, a valid conclusion. Thank you.
Thank you.
Thanks to the experts.
Thank you, Deborah, for your guidance on this and your views, your expert views, and I concur with Eddie Williams in thanking both officers and our expert witnesses in the diligence with which they've proceeded with this matter.
Thank you very much. Are you happy for me to leave the meeting now?
Yeah, I think the meeting's just about over. Yeah, so thank you very much, Deborah.
Thank you very much.
Amy, there being no other business, I have no other business notified.
That's correct, Chair. There's nothing considered urgent for yourself on the agenda under Part 1 or Part 2 today.
Yeah. In that case, can I thank everyone for their time and efforts on this committee, and Amy for her support, and have a good day.
Thank you very much, Chair.
Nice. Yeah, bye-bye.